How many jobs have you been fired from in the past 5 years?
Probably not the first question you would ask your client.
I Googled this, and this is called an ineffective assistance of counsel.
Calendar year of 2021?
Oh, we got the sleeping
notice?
juror. I know right now you're sitting there and you're like, this show is ridiculous. People fall asleep on jury duty all the time.
He's showing very clear frustration. He's banging his hands on the table when his attorney can't present a simple video.
Choose your injury lawyer wisely, y'all. Hello again, Mark Breyer from the Husband and Wife Law Team, a real-life trial lawyer talking about videos that we see, some real-life trials sometimes shows. Today we're gonna go over jury duty. A couple quick things. Number one, guys, it means a lot to me. I really appreciate how many of you are subscribing, the number of comments we're getting, the suggestions. It means a lot to see all the positive feedback. If you haven't subscribed, just right now, go ahead, click that subscribe button. Join the growing masses. I'm not a legal commentator who's never gone to law school. I'm not a lawyer who's never been in a courtroom. This is where I live. Today we're going to talk about jury duty, and it's a show where we actually have one guy who actually thinks he's been selected for a jury. Everyone else is an actor. The jurors are actors, the judge, the witnesses, the lawyers, and we're gonna have some fun dissecting that between some real world stuff and some other stuff. Now, we're getting a lot of people reaching out. So I'm here to try to talk about this stuff. But people, if you have questions on a real case, whether it's an injury case, whether it's something else, you're like, man, I just want someone to give me an honest answer. Feel free to call this number right here. We will do our best. We'll answer your questions. If it's something we can't help on, we're very open about we can't help it. If you don't want a sales pitch, you just want answers, that's really how we're built. That's just who we are. So now let's get to the fun stuff. Ready? Comment away. Let us know what you think. We're gonna start with jury duty. And as always, the people behind the camera, the production team has lined up stuff and I have no idea what I'm gonna look at.
Can I kiss you on the cheek? If not, I can pretend.
Anytime we do a movie, somehow it comes out that he's Cyclops and X-Men.
It's not every time.
Every single time.
Yo, this is actually like a crazy situation and even crazier in LA, right? Famous people do show up on juries. What happens? They're just on the jury with you. Show up to jury duty, serve our society, serve the court system, make sure justice happens, and meet your favorite athlete. They are not exempt from being there. They have any given Sunday, they got to be on jury duty too. So here's the thing. What if someone's in the NFL season? Are we going to make them miss a week of practice? No. They're going to raise their hand and everyone's going to probably know and go, well, I'm the left tackle for the such and such team here in town. And I game week. All right, well, do you play all year? No. We'll have you come back here during the off season. So we adjust for some of that. You're a celebrity, we can adjust for it, but celebrities do end up on juries. They get the same jury summonses you and I get.
Calendar year of 2021?
Oh, we got the sleeping juror. Right now, watch
July
this. Watch this.
To December 2021.
I know right now you're sitting there and you're like, this show is ridiculous. People fall asleep on jury duty all the time. And it creates real issues because if the person falls asleep and misses some of the testimony, how can they give a verdict on testimony they didn't hear or exhibits they didn't see? But if you send that juror packing and another juror gets sick, something happens, you may have to start all over. Imagine going through a 6-week trial and you're starting all over because you got rid of a juror who fell asleep after lunch a lot. Be careful about the witnesses you present after lunch because that is the time your jurors may fall asleep. If you have to do an opening or closing after lunch and you see someone falling asleep, bring the energy up, find a way to walk towards them, engage with them without embarrassing them or making them even know that's what you're doing, because falling asleep during jury duty, we see it all the time. It's good when it happens to when the other side's up. If I see someone nodding their head and struggling, I will do what I can to make sure I re-engage them because we need them on the jury and we need them actually hearing what's happening.
Barbara can't stay awake. She's literally falling asleep in the juror box. It was either 5 or 6 times in total. Jeannie and I had to wake Barbara up.
Do you solemnly swear that the testimony you are about to give shall be the truth and nothing but the truth?
I have had judges literally call jurors into the courtroom and say, is something wrong at home? Is there a reason you're not getting enough sleep? And some judge will say, you look like you're falling asleep, but no judge really wants to say that because that creates appellate error. So the judge will be, it looks like you were tired. We all know what was happening, right? But no one wants to create a situation where on appeal, someone goes, this judge left a juror there who was sleeping and missed key testimony. We want a new trial.
What do people usually say when they're trying to get out of this? What's the move?
If you've watched my videos, you know the move. Don't do the move, but the move is there for you. If you don't know what it is, you haven't watched enough of our discussions about trial stuff.
I'm only going off the thing I've seen on Family Guy, and that's probably not the best thing to use.
Wait, what was it?
When Peter pretends to be racist to get out of jury duty.
It's pretty smart.
This is called voir dire, and the English translation of the French voir dire is to speak the truth.
I actually, I have this trip with my girlfriend. It's our 6-month anniversary.
A trip.
Yeah, this is the first time that we've been completely unsupervised. Our parents aren't there, so you can kind of see how that would be like a big...
Sir, a vacation is not an excuse. I've
complete-
heard...
It's just that our parents aren't going to be around, so we're really free to do anything that we haven't done yet.
Right.
Excuse me. I've heard it all, and going away with your girlfriend, that's not going to suffice. I'm terribly sorry.
If that were to be the case, if somebody has a trip planned and let's say that it's a non-refundable trip, are they reimbursed for that if they're now legally required to be part of the jury?
We can't reimburse jurors. Someone's got to pay it, right? People talk about, well, the court will pay for it. Well, the court is the government. Well, the government will pay for it. Well, there's only so much tax money. We don't have enough judges. That's why people wait so long for a trial. We don't have enough court staff. That's why the judges don't have enough help to sometimes move cases through. So paying for a trip, we can't do. What we can do is allow the person with the non-refundable trip to go on the trip. However, 2 issues. 1, that person may have to come back another time when they don't have a non-refundable trip. And 2, there is, again, the risk of now we're gonna have to start this whole process over because we ran out of people. So judges are hesitant. There's always the balance. I've seen judges who literally let anyone who raised their hand go. And I've seen people go, I'm afraid I'm not gonna be able to pay for stuff. This comes up all the time. I have a trip planned, I can't get out of it. All right, well, I want you to call your travel agent type thing. Like not literally, but figuratively. I'm gonna take a break and I want you to figure out a way out of it, which is going a little bit far. And sometimes you have a situation like in this acting, and the guy, we know behind the scenes, he just wants off, right? Sometimes everyone in the courtroom knows the person's full of it and they just don't want to serve on jury duty. And some judges are much more like, if you don't want to be here, I don't want you here corrupting this panel and this process, which matters to the litigants a lot, to the people involved a lot. And some people are like, I'm not letting you get over on me. I know you're lying, you know you're lying. I'm gonna make it hard for you and I'm gonna keep you here. Unless you use a move that makes it really hard, which I think might be coming here.
Sir.
I also am racist.
Sir, please have a seat.
I'm sorry. You're a racist?
No, I'm sorry. I'm not racist. I was told that would work.
Who told you that? All right, never mind. If I put you under oath, you would attest that you are not a racist. Is that correct?
No, I'm not. I'm sorry.
Okay.
You would usually already be under oath, by the way. Before you give answers in a courtroom, you're sworn to tell the truth, to get just like any other witness would be. In theory, saying I'm a racist would not matter in every single case. It would only make you hated by everybody in every single case. It may not even get you off.
Don't be racist. I am a building.
The guy we're looking at on the screen, he actually doesn't realize everyone else is an actor. The guy who just said he's a racist, he's in on it. He's part of the brilliant gag that we're watching.
Counsel?
I think I'm gonna let this group go, Your Honor.
Yeah.
Please.
So here's the way a trial goes, the same way it happened in the show. First, people are called for jury duty, then we select the jury. We actually do not select a jury, we deselect a jury. So we don't pick who we want, we get rid of the people that the court or the parties don't want. And that's why your favorite people are never on the jury. Because if you want them, the other side doesn't, or you want them because they're vocally obviously gonna be on your side and the judge gets rid of them. So usually your favorite people do not make it on a jury in most states. Arizona is the only state in the country that doesn't have peremptory challenges. So you can end up on a jury. We just had a police chase case that our firm tried, and sitting on the jury was a prosecutor, a current prosecutor who works with the police every day. And we were suing the police for a bad injury caused to a totally innocent person because someone started chasing a car over expired tags. For those that don't know, that's a really dumb, dangerous, stupid thing for an officer to do, to start a high-speed chase over expired tags, at least was our opinion. On the jury was a prosecutor. In 49 states, that prosecutor never makes it on it. So anyway, we finished picking the jury. Now is opening statement. So we're gonna see the opening statement of one of the parties who, remember, only one person sitting on the jury doesn't realize this whole thing is a sham trial.
Mr. Sanders?
I love the Mr. Sanders. By the time you get to opening statement, you have been in front of the judge for pretrial motions. You've had discussions with the judge that morning before the jury came in. You've gone through the whole jury selection process. At that point, the judge probably knows your name.
And I want to assure this court that we also have a video presentation that is pretty phenomenal. And I just need a moment
struggles with technology, if you've been on a jury in the last 20 years, it probably drove you nuts watching lawyers try to get their technology straight. By the way, when I started using technology in the courtroom, the judges that I was using it in front of had never seen it before. I was the first lawyer they had seen use the technology. No one else was using computers, and some of them loved it. We had a judge here, Judge Kaufman, who was asking me questions about it, was raving about the impact. I had other judges stop me from using it because they hadn't seen it. So now everyone uses it, but not everyone uses it well. And no matter how well you think you know it, right in front of the jury, it's gonna do something you weren't ready for.
And it is coming from the cloud as we speak. So if you will just give me a second.
So when I heard about this show, a paralegal on our team that I've tried many cases with said she loved the show. That's because she and I have sat there many times watching this kind of stuff happen. While the jury's just like, come on. The judge is like, come on. And if you're the lawyer that's up there, and it's been us, but fortunately, more often than not, it hasn't, when your technology's not working, it's the worst.
I'd be mad if that was my lawyer. I'd be pissed.
I'm joining the Wi-Fi as we speak.
This is your opening.
I'm so sorry about this, Your Honor. It's been a day. It's been a day.
We're going to break for the day. You guys go back to your hotel, and we'll get a fresh start with Mr. Sanders. You're going to have a...
By the way, go back to the hotel sequester jury thing. Very, very unusual. It happens, but it happens rarely.
Presentation tomorrow.
Dynamite, Your Honor, first thing in the morning.
And I will pick that foreperson when we reconvene tomorrow.
And judges don't pick the foreman or forewoman, foreperson in most jurisdictions. That's not how it works. The jury picks it, and they pick it themselves. The judge doesn't get to intervene in who the foreperson is.
Little chilly in here today, but I'm about to warm it up with the heat of justice.
By the way, that would almost always get the judge to either call you out right there in front of the jury or call you up and just lay into you. Yeah, you don't get to make your little comments. I mean, that was kind of funny. Remember, an opening statement, you have no credibility. The jury doesn't know you. It's even worse if you're defending someone, and I don't know if this is a civil or criminal case, we'll find out in a second. You're defending somebody, they don't have credibility potentially, and you start out by playing Superman, probably not the right move.
Wait. You mean to tell me you don't have a catch line when you walk into court?
Oh, I have a catch line when I walk into court. I just don't share it. I wait for the right moment.
Damage and emotional distress in the neighborhood of around $2,500. Now, $2,500 is a lot of money.
Counsel, it's $1.8 million. You just said $2,500. I'm sorry to interrupt. I just don't want the jury to be confused.
I'm sorry, Your Honor. I have a lot going on. I think I might be looking at the wrong.
I kind of feel bad for him, just because he's trying his best.
We were supposed to have filed it on Wednesday, and I'm so sorry. Yeah, I'm literally in court on another case right
Counsel?
now. Yes, Your Honor.
Are you talking to me? Counsel?
I'm sorry?
Were you talking to me?
So when you're in front of a jury, they are always watching. One of the things we talk to our clients about is the jury is not just watching you when you testify, they're watching you at all times. But it's not just the client. You, as the lawyer, your credibility. So to take a phone call like this with the jury watching is something you should never do. And really, it's not something I've seen done a lot. Now, what I have seen people do a lot is pull out their phones and start texting. One of the issues we have in court now is that we will use our phones to control all sorts of things. I'll use the Wi-Fi. Sometimes I don't want to use the public Wi-Fi from the court. I know. Come on, Mark. No one's tapping in to the public Wi-Fi to see. Probably not.
Jesus Christ, that's Jason Bourne.
I will sometimes ask the judge to tell the jury that, you know, the phone is out for a reason. Sometimes I'll, on my own and kind of voir dire, just happen to mention that, oh yeah, I'm using my phone for Wi-Fi and to communicate with my team. The jury doesn't have their phone out. They're stuck there. The rest of their life, they're allowed to have their phone. Now they're stuck there with no phone. So that's an issue, right? So something to keep in mind. He's taking this call.
As promised, I have an animation today that is equally awesome to the animation you all saw yesterday. So let me just get this set up. I assure you that this will be worth the time.
And let me tell you something, you are definitely hooking up that technology before the jury shows up that day. You are not doing it in front of the jury on your opening statement. Sometimes you have to, between witness, you have no choice. We call a witness out of order. Something comes up with the witness on direct, I didn't expect it. I didn't know I was gonna be using this. I have no choice. There are times where I have to do it in front of the jury, but in terms of actually testing it out like this, that is not what you would do.
Today?
Absolutely, Your Honor.
Oh my God.
I'm so sorry. I'm so sorry.
Okay.
I got this video queued up from the cloud. I've not had an opportunity to watch this yet.
Are we showing it on the screen?
No. I'm gonna do it directly from this guy. So, as you can see here, my client showed up for work on the day of the incident, and this is just a second. I'm gonna have to have a talk with my nephew.
Wait, whoa.
You know what?
I want to see it. Is this what the jury just saw?
By the way, you've already had to share your exhibits with opposing counsel and the court before you're showing it to the jury.
It's like the defendant is getting hosed.
He's showing very clear frustration. He's banging his hands on the table when his attorney can't present a simple video. It's a hot mess.
Woo! Choose your injury lawyer wisely, y'all.
Oftentimes where there's an accident or someone's claiming that something happened, you do things like that where you create some sort of animation to relay to the jury what your side is claiming happened. So obviously in your experience, you probably haven't seen anything quite like that.
You mean to tell me you don't think that Mark's ever had a Gary's Mod animation that rubber bands like crazy used as witness evidence?
We're gonna get a little technical here. The difference between an animation and a simulation. An animation is someone going, this is about what happened, where the simulation actually takes measurements, expert data, and plugs it all in and goes, this is exactly what happened. The power of an animation or simulation is so high that you can't just play them for a jury. You need court approval. The other side will always object, almost, because there's a power that happens when you actually see the description of what happened. So we're trying to keep the other sides out. They're trying to keep ours out. You need to lay a predicate through your expert often to say, this is why it's built directly off of this. Sometimes I'll hire one expert to do all the measurements and all the data and all the calculations, and a different expert in simulations who can say, I can tell you this is exactly what I was told, who has more of a background in computer science, so that no matter which way they attack us, I have an expert who can handle it. Because a lot of times the experts in reconstruction, as an example, like from that video, aren't experts in the computer program. The computer program experts aren't experts in reconstruction, although there are people who have expertise in both. Animations, where it's what you just saw, just someone go, this is about what we say. Very often you can't show that to the jury because we know the power of video. So for you to throw something out there as if it happened when you can't prove that's exactly what you're saying is happening, you don't even have evidence to support it, you're not allowed to do it. So now the guy who's suing is being called to the stand and he's gonna testify. It's called direct exam. We ready?
Mr. Morris, how many jobs have you been fired from in the past 5 years?
Probably not the first question you would ask your client. However, there is something about taking the sting out of what the other side's gonna do. If I have a client and I know on cross-examination they are going to attack this client for something that's gonna look bad, do I want it to come out for the first time on cross? No, I want it to come out on my exam. So why would I not start that way? In theory, if the other side, if that was their whole case, I may start with their strongest point. Let's freaking dunk on them right now, and you're gonna have your chance to refute their nonsense that they've been saying about you during their opening statement or however long the trial's gone on. So I will sometimes start where they're not ready. I will sometimes start with what they think is their strongest point and come out right to the jury going, we're not afraid of this. But generally, you want to start by letting the jury get to know your client and let your client gain some credibility and let your client gain some comfort. So every case is different. If it has not been a main point that they're going to worry about, like how many jobs you've been fired from, you're probably not even asking it. You're moving in advance to keep it out of trial because it's got nothing to do with what's going on.
His attorney took an interesting tactic.
And your mother testified that she's observed you drinking and smoking pot almost every night of the week. Is that also correct?
I was confused.
In fact, the only character witness who had any good things to say about you at all is some dude who in public to robot movies. Is that accurate?
What are you doing?
What I'm saying is, with your record of kind of unsavory behavior at work and in your own personal life, and kind of no redeeming resume points to speak of, whose own mom has kind of called him a dirtbag and doesn't want him in the house, would you even hire you? Don't you think it would be kind of irresponsible for anybody to hire you to come and work for them?
No, that's enough. Stop. I Googled this, and this is called an ineffective assistance of counsel.
Well, wait just a second.
So I would like.
Ineffective assistance of counsel is only helpful in a criminal case. If you hire a bad lawyer in your civil case, you are stuck with that bad lawyer. Do your research.
Hold on. I would like to meet with the defendant, and I'd like to meet with his counsel in my chambers.
By the way, this meeting would never happen. Never, ever, ever. Why? Because this would be ex parte communication.
Here I come.
You can't go talk to the other lawyer and the other party, and now I'm stuck in the courtroom and I don't know what you guys are talking about. If the judge is going to talk about the case, I have a right to be there. So this meeting is not happening. On top of that, you wouldn't do it right in front of the jury, and the jury just watches you leave to go out and have the conversation.
Mr. Morris has chosen to represent himself for the remainder of the trial. His counsel will remain as co-counsel, but he's going to finish his examination. He's going to do his own closing argument. So with that,
yes, you can
luck.
represent yourself. It's a really bad idea. It's an old statement.
Say the line, Bart!
A person who represents himself has a fool for a client. No matter how good you are, it would be a very challenging thing to represent yourself well. Number one, you're obviously going to be more biased. But number two, if I stand up and I tell you how much I care about clients, how hard we fight for clients, all the things we built in to make sure that our clients get a higher level of service and understanding in the way we explain things than anybody else, I may be effective. If you heard all the things that I do in my business and what we do to have the right team members, educate the team members and build culture and be there, that might be effective. You know, it'd be way more effective, someone else saying the same thing. It's just naturally true that when someone else stands up and goes, you would not believe what Mark and Alexis have done in their business. There's something far more powerful about someone advocating for you than you self-advocating. And I'm not saying never, but almost never would representing yourself be a good idea. On the other hand, if we've seen the way his lawyer's going, maybe. Like, it might be better than that guy.
Would you please introduce yourself to the jury?
Hi, I'm Genevieve Telford Warren.
Can you describe for the ladies and gentlemen of the jury what it is that you do for a living, Ms. Telford Warren?
Sure. I am a social media brand ambassador for myself, for my own account, and for a third-party account as well, which belongs to my dog, who's a pet.
Interesting. Of course, she's an actor, but did you see how she's hearing the question and then turning to the jury? So you got to be careful with that. On the one hand, if you look me in the eye, you're more believable. So looking at the jury makes sense. On the other hand, you can't look like it's some fake. So what I encourage my clients to do and witnesses that I'm advising is consider that you're in a conversation with many people. This person's asking the questions, but they want to hear the conversation as well. Now you're talking to everybody, not just turning to face the jury, which feels fake, or never looking at the jury, which hurts your credibility.
I just don't know how all these actors didn't break. I don't know if you caught it in the last clip where the guy was showing the animation and the one girl had to turn away because she was laughing so much.
Although to be fair, you might have laughed anyway. Like, that's staying in character-ish.
Anybody else felt like that?
Exactly. Maybe pinch
right in the throat.
Look, here's the thing about witnesses you call. It matters who you call. It matters if they're prepared to testify. Do they even know what questions are being asked? Now remember, this is not a party. So if I prepare a witness I'm calling, the other side can say, did you meet with Mr. Breyer? And what did Mr. Breyer talk to you about? It's not privileged. It's a witness. So you can't prepare the same way with someone when the preparation could come out in cross-examination. So, you know, it's something to keep in mind. So you better make sure you're calling the right people and you're calling the right order and they make sense. This does not appear to be a witness you wanted to call at all. This is it. The big reveal is about to happen. This man is sat on a jury. He's done his time. He's done his service. He's about to find out it was a fraud. This is like, what's that Jim Carrey movie?
The Truman Show.
The Truman Show. He's about to find out. This could be traumatic. It could be traumatic. This is going to be interesting.
Weeks ago, when you first entered this courtroom, that this was the last trial of my career, what I didn't tell you is it's also the first, because I'm not a real judge. And you're not a real foreperson. This is not a real case.
What?
Each of your fellow jurors, as well as the defendant, the plaintiff, bailiff Nikki, myself, we're all actors. Everything you saw was carefully planned. What I'm saying is, it was all fake, except for one important element. You.
See that? I think that would totally mess with your mind. Like, that's crazy.
And we've decided that you, Ronald Gladden, are a hero. In recognition of your service, your kindness and strength of character, I hereby award you the sum of $100,000.
What? That's the don't sue me $100,000. That's, see, we just messed with it. No, I'm just playing. That's
Ronald,
what?
This case is now adjourned.
That is wild. Wild. What if this whole thing for 30 years with my wife is just a sham?
I guess it just kind of goes to show, like, even in like the craziest situation, the importance of at least having one very brutally like focused and honest and fair juror could make a huge difference.
Look, this is my opinion. I have done countless focus groups and have no idea how much I've read, no idea how many experts I've watched, all the trials I've done. There is no group dynamic. There is no jury decision. It is all about your leader, period. On a jury in a small group dynamic, if your leader is outnumbered, the true leader, not the 4-person, the true leader could be outnumbered. Let's say you have a 12-person jury, 11-1. You still have a good chance of winning if the clear leader on the jury has a chance to influence others. And people will go along with leadership. So your 1 or 2 leaders, that's what matters. Most people are going to follow the leader at a moment like this. That's my strong opinion. So when I'm looking at who to leave on a jury and let off when I have 1 strike left in peremptories, or when I'm deciding who to get rid of, it's the people that are likely to lead that matter the most. We are almost there, y'all. We are almost at 100,000 subscribers. We started this journey together and we said, let's give it a shot. And because of your comments and suggestions, if you have other shows or anything else you'd like to hear from a trial or you'd like to hear from me, comment, please put it in the comments. Let us know. If you haven't subscribed yet, please do that and join this growing community, having fun and going over these things together. And oh, right there, that's me talking about another show, giving some thoughts on it. So if you enjoyed this, click that, watch that as well. Thank you for joining us here. Mark Breyer, the Husband Wife Law Team, and I will see you soon.